Hi there, my name is Jonathan Herring, and I'm one of those involved teaching on the mental capacity, choice and the law course. And the idea is just to give you a brief overview of this course. A key question at the heart of this course is who can make decisions for themselves and why. I enjoy eating gooseberry yogurt. You might think that's a very unwise decision. Perhaps you think it's unhealthy. You might think it's an immoral decision. I shouldn't be eating animal products, for example. And inevitably then the law comes in. To what extent am I allowed to choose what I want to eat and when? That, of course, is a rather trivial issue. And the course mainly concerns much more serious issues about when someone can make decisions about medical treatment, where they live, who they have relationships with, that sort of thing. Now, there are many reasons why the law might want to stop someone doing something they'd like to do, for example, that it harms others. The focus in this course is when the law might say that someone can't make a decision for themselves because they lack the mental capacity. So the course is designed to look at this very broadly. It brings together family lawyers, medical lawyers, and we particularly wanted to consider how these issues around mental capacity are different when involving children, when involving adults. So we'll be looking at issues involving teenagers when they're allowed to make decisions about medical treatment or where they live, or aspects of their lives, but also issues around those with dementia or those with other issues affecting their capacity as adults. So I'll just take you through some of the seminars. The first seminar is a general introduction. We'll introduce you to the basic coverage of English law. That we'll be using as our primary resource. Although our main interest will be in the broader theoretical issues, you can only really understand those with an understanding of a particular legal system. So Seminar 1 will introduce you to English law on mental capacity. The second issue will be looking at the more philosophical literature. Why do people why do we respect capacity, and particularly autonomy? And what is the philosophical basis for that? The third seminar will be really following on from that, but looking to some of the critical challenges to capacity. Those who are perhaps rather sceptical of the idea of capacity. Those come from a range of interesting schools. There's feminist analysis, arguing that capacity tends to be too individualistic. Disability rights advocates sometimes argue that tests of capacity discriminate against those with mental disorders. Child liberationists can claim that the law on capacity disadvantages children by not respecting their decisions. So we'll be looking at some of those challenges to the idea of capacity in Seminar 3. In Seminar 4, we'll very much be moving on to the law itself and looking for the tests for capacity. What are the tests for capacity for adults? What are the tests for capacity for children? And we particularly want to think about what are the differences between those. Are they essentially the same questions? Does someone have sufficient understanding? Or are there different issues around capacity for children and adults? And some of the recent legal cases have been particularly interesting on that. In Seminar 5, we'll be looking at people on the borderline of capacity. So what about someone who has been found to have capacity but only just? How does the law deal with those? Do we need a third category? Those who have capacity, those who don't have capacity, and those who just have capacity? Or is it more helpful to have a sharp line? Similarly, how should we respond to teenagers where there's a feeling, well, yes, they do have some understanding, but we're just concerned about the fact that they're still children. So we'll be focusing particularly on those in that seminar. In Seminar 6, we'll be looking at the issues around those who lack capacity. How do we make decisions for people if they're found to lack capacity? And again, we'll be particularly interested in contrasting adults and children here. Under the Children Act, it's the child's welfare which is the paramount consideration. Under the Mental Capacity Act, it's an adult's best interests. Well, are best interests and welfare the same thing? And if they differ, how do they differ? To what extent should we attach weight to the views of those who lack capacity? In Seminar 7, we'll be looking at two particular case studies, advanced decision and trans and gender questioning children. Both of these raise some very interesting questions and complex questions about future selves. To what extent can a self at one point in time make decisions which will have significant impact about a future self? They also raise issues about identity. To what extent are someone's beliefs or self-understandings tied to their identity? That seminar will be drawing on quite a few of the issues we've been discussing throughout the course. In Seminar 8, we'll be trying to bring things together, looking at some of these key questions. Are tests for adult capacity and children's capacity different? Should we be using different kinds of tests for children and adults when they lack capacity? And returning to some of the critical concerns, is capacity a useful test to use at all? So just a few general things about the administration. The course will be taught by myself, by Professor Imogen Gould and Professor Rachel Taylor, and that will be drawing on expertise in both medical and family law. We'll also be bringing in some philosophers and others who will help enrich the course as well. The assessment takes place at the end of Michaelmas term and will involve two 2,000-word essays. Thank you. I think that's all I wanted to say about the course, but please do get in touch if you had any questions yourself. Thank you.